Thanks for joining us. This is The Economy. My name is Ibrahim Sani. As usual, we're at the environment of where we want to have the conversation. Currently, I'm at the offices of Lee Hishammuddin Allen Gledhill. And of course, joining me on the show is a long-time friend of mine, Datuk Nitin Nadkarni, the consultant at Lee Hishammuddin Allen Gledhill. Datuk, thank you very much for taking the time to speak with us. The last time we spoke, it was more of the precipice of what the decision is going to be when it comes to the Sulu case. Right now, last month, we've seen how Malaysia has welcomed the ruling on the High Court of Justice of Madrid, stating that reinforces the government's commitment to defending the country's sovereignty and immunity against the Sulu claim. Generally speaking, we're accepting the fact that the toss out of the claimants are now done and final. Do you yourself welcome this kind of result?
Yeah, well, good morning, and thank you so much for coming to see me and inviting me onto your show again. Yes, I mean, what's happened is a heartening change of events from the disastrous situation we faced a few years ago when you had this enormous award for billions of ringgit, potentially registrable in 172 countries around the world and usable not only against the government of Malaysia, but things like Petronas, QAP, EPF, all of the assets owned by the government and other government agencies. Potentially, I mean, there were defenses, but potentially enforceable against them. So now we've had a complete, the government has had complete victory, I think, in every jurisdiction in which this arbitration award is being considered. In Spain, the Spanish court said the arbitrator should never have been appointed. They revoked his appointment. When he refused to comply with the order revoking his appointment, they basically sentenced the arbitrator to prison for contempt of court for going ahead with the arbitration. And they revoked then in France, the arbitrator made a two-step decision. First, he ruled that he had jurisdiction. Then the Spanish courts had said, look, you cannot proceed with this arbitration because Malaysia wasn't properly notified of these proceedings. He then moved to Spain, he moved from Spain to France. The award on jurisdiction was registered in France. He said, France recognizes, I don't care what Spain does, I'm going to give my final award in France. The French courts have now held that there never was jurisdiction because they're saying there wasn't a valid arbitration agreement. So they've set aside, at the behest of the Malaysian government, they've set aside the preliminary award on jurisdiction. And obviously, if there never was an arbitration agreement, it just is a matter of time before they set aside the final award as well and say that since there wasn't an arbitration agreement, there is no arbitration award. The Dutch courts have also set aside the attempt to register the award, saying that, look, the Spanish court, which appointed this arbitrator, revoked his appointment. He had no business going and giving a final award. So it has been, so far, a complete victory for the Malaysian government on every front that they have fought this case.
The last time we had this conversation, you said that there is a possibility that the arbitrator can just shop around for any other jurisdiction that will give him the airtime.
Well, there's two things. One is the arbitrator can't. He's going to prison. And a jolly good thing that is too, because I think it'll send a message to other arbitrators not to behave in this manner. I can tell you that in the arbitration world, every conference I went to, when this case was brought up, all the arbitrators, all the counsels, senior counsels, were always shocked at this award and always said, this is going to be set aside. There is something inherently wrong with this. But the point is, even though the French courts have declared this, even though the Spanish courts, the Dutch courts have said this, there is a general principle in some jurisdictions that they don't care what other courts have said about an award. So the award itself, that document, that piece of paper, can still be taken to other countries where perhaps they have a different view of these matters. Not European countries, because the European judgments now, in EU all apply. Not common law countries, because common law countries would never even have recognized there as being an arbitration agreement in the first place. But other countries, I don't know, maybe in Central Africa, Central Asia, South America, we don't know how these things will be recognized. We don't even know how this award would be recognized in the Philippines. Bear in mind that as far as the Philippines is concerned, Sabah, they have a claim to sovereignty over Sabah.
Yeah.
So we don't even know how they would recognize this arbitration award. So that is the problem with an arbitration award. If it is not nipped in the bud, if you don't nip the proceedings in the bud, once the award is issued, you may have to fight in 172 countries, each of which has a say in whether they wish to recognize that award or not.
Do you think that the government of Malaysia has had ample time to take lessons from this and not just talk about the sovereignty of how Malaysia's borders are going to look like, but how we operate, generally speaking, in the future?
I would love to think that the Malaysian government would learn lessons from this. But does history teach us that the Malaysian government learns, or do they just say, okay, problem solved, now let's get on with life? I have not seen any indication of structural changes by the Malaysian government. Okay, well, let's look at what started this. You had the Lahad Datu intrusion. We'd been paying on this lease, installments or whatever, annual rent on this lease for years. You had the Lahad Datu incursion. As a knee-jerk, what I might call a Donald Trump response, the Malaysian government said, we're not going to honor this lease anymore. There was no thinking, there was no taking of legal advice as far as I know, no consideration, what are the implications. It was just like a Donald Trump. But we're not America, we can't behave like Donald Trump. They just said, we're not going to honor this, and that's all there is to it. That's what triggered the arbitration award, the arbitration being brought out. Then when those proceedings came, the attorneys general didn't take it seriously as they should have. Or at least it appears to me that some of the attorneys general did not devote the resources that they should have to this. We used to have a very fine international division in the attorney general's chambers that would look at international treaties and international. We may still have, I don't know.
Yeah.
But you know, I'm not sure that we learned or we learn. And the example I always give is the Pulau Batu Putih dispute. Did we learn to make structural changes in how we approach matters because of that? If you look at Pulau Batu Putih, there's a fascinating book written by a Singaporean, Professor Jayakumar, who was one of the counsels. He says that Singapore started preparing for the Pulau Batu dispute in the 1970s. They delegated a team of people who was going to look at this dispute. And these were people who were doing their masters or whatever in UK at that time. They sent them off to Kew Gardens. They were on scholarships, told them to research this. These same people were kept in charge of this same file. They joined the government services. They looked at this file all the way till they retired. And after they retired, they were called back. So you had that complete continuity for 35 years where they knew exactly what was going on. I don't know, but I suspect in Malaysia, we just kept changing the people, and each person who came in had to learn from scratch, and then you lose something in the process.
Yeah, you don't have institutional memory.
You don't have the institutional memory. You have the paperwork, but that's not quite the same thing. Again, with this, as I say, if we'd learned from Pulau Batu Putih, then we would have applied those lessons to the Sulu thing. We wouldn't have made a Trumpian knee-jerk reaction as to thing. We would have considered the matter, looked at the background, and what are the possible implications.
What about the roles, the law minister role, the separation of prosecutor with the AG? Does these things work?
Okay, you're now moving to a different question. In theory, one should separate the Attorney General from the public prosecutor. I think absolutely one should. The public prosecutor, the theory, the legal theory would be as a civil servant. The Attorney General would then be the advisor to the government. The DPP would be a civil servant, independent, and who would not be subject to any political pressure and would make decisions without fear or favor. These are all nice phrases, but you can't. But it depends on an understanding that you must appoint the right people, and more than that, it requires an understanding from the powers that be when to restrain themselves from exercising power. A lot of the powers of civil servants and judges, these are weak divisions. They really are. If you look at it institutionally, they have no power. Their power comes from self-restraint. Even in the most developed of countries like the US, and I come back to US because it's such a good example, where you have such a strong separation of powers. But Donald Trump can and has replaced the Attorney General, replaced prosecutors, and he's putting in place people who answer to him, even in such a developed, mature democracy. He's not exercising self-restraint. So in a country like Malaysia, which is a young country where we're still finding our way, if the powers that be don't exercise self-restraint, and there is a lot, then all these institutional reforms won't make a difference. Have the powers that be exercise self-restraint? Our first 3 prime ministers were all lawyers. All of them understood these constitutional principles. It's well known that they all exercised self-restraint. Civil servants, heads of departments, attorneys general were very powerful. If they said this is the position, it applied. I am not convinced that the subsequent prime ministers acted in that way. Maybe from the best of intentions. I mean, our 4th prime minister wanted to get things done. He wasn't interested in why I can't do things. It was get it done. I want to move the country forward. And that was a laudable aim, and we see the progress in the country, but in that process something was lost, I think. The concept that you need to empower and exercise some self-restraint when you are dealing with institutions of justice. You cannot deal with institutions of justice, whether it be the courts or the prosecutors, in the same way as you might deal with a civil servant in the Ministry of Finance or a civil servant in the JKR. You know, there must be a difference in the way you treat them. And that, I'm afraid that none of our subsequent leaders, we've only had one subsequent prime minister who was a lawyer, and that's Ismail Sabri. But of course, there are other issues about that now. And to be fair, he was only prime minister for a very short time. There was no question of institutionalizing these kinds of frameworks.
And then, of course, we have to look into how the country is being governed today. And there's a lot of conversations into how income is going to be looked at very differently, how we get income, how we manage our funds, how we derive revenue from the various institutions that exist today. Do you feel that we are on the right track when it comes to how government gets revenue for the nation? Okay,
let's take a step back. In Tun Dr. Mahathir's time, in some ways he had it easy, because Petronas, our oil revenues and oil-related revenues were so huge that they amounted to half almost the government's budget. So there was free money, durian runtuh, that financed the government. Today, we don't have that. Our demands on the public purse have increased, salaries have increased, we want to spend more money on other things. Meantime, petroleum revenues have decreased. Somewhere that shortfall has to be made up. I think I've said this once before in your program, GST was part of the solution. But for political reasons, it's now gone, unfortunately. We are one of the few countries in the world that doesn't have a value-added tax. So that money has to come from somewhere else. And where is it going to come from? And this is a problem. I think a French finance minister in the 16th or 17th century, Colbert, once said that the art of taxation is the plucking of the maximum amount of feathers from the goose with the minimum amount of hissing. What seems to be happening now is that the inland revenue is not only plucking feathers, but I fear that they may be slaughtering some of the geese that are there with the somewhat aggressive approach that has been taken in the past few years. I've had this conversation, especially in the past year, I've had this conversation with some of my foreign investors who have businesses here, and they are saying, well, we are reconsidering because tax is an important reason why we relocate or we allocate our businesses, particularly our head offices, in any particular country. And if the tax regime becomes unfavorable here, then we will relocate to another country. The world is open to us. So there is that problem that we have. I think there needs to be, if we are to have an aggressive tax department, and you know, I accept that sometimes revenue has to be aggressive and they have to catch people who are evading, not avoiding, but evading taxes. Because when one person evades tax, that means those who pay their taxes are bearing an unfair burden. But there must be a proper recourse, and that is what we are lacking. There is no proper recourse mechanism against the activities of the inland revenue. The Parliament has said, if you don't like what the inland revenue does, go to a special body called the Special Commissioners of Income Tax, or if you don't like what Customs is doing, go to a special body called the Customs Appeals Tribunals. But these cases take a long time. Last year, I finally got a decision in a taxpayer's favor. This is 2024, in respect of an assessment that arose from income in 2006. There's a famous phrase, justice delayed is justice denied. And 18 years is a huge delay. You must have a recourse against whatever the revenue does,
but of
where
course
you can be
in
heard
that case,
within 6 months, 9 months, 1 year, 2 years maybe. Fair enough.
But in that case of yours, were there any interest paid?
No. So when we finally get back the money, there's under the law, the Inland Revenue just gives you back your money. They don't give you any interest. The cost they pay is minimal. So taxpayers, basically you're kept out of your money. In that case, I think the assessment was actually in 2012. You're kept out of your money for 12 years and you get back money today. And I think all of us know that money 12 years ago was worth more than money today. And sometimes it's 15 years. And there are delays along the process, and these are sometimes I think the Ministry of Finance creates institutional delays. So when I started practice in 1985, if the revenue made a decision and you appealed, within 6 months the case had to go to the Special Commissioners of Income Tax. Now that has been extended to a year. Now once it gets the Special Commissioners of Income Tax, they have to hear the case. For that they need sufficient manpower. And when you have a very aggressive Inland Revenue, you must therefore have enough judges at the Special Commissioners that they can expeditiously hear the appeals. We don't. We don't have enough judges. The judges who are there are under tremendous pressure. That means it takes time to get your hearing. The judges then have to find the time to decide your case. They then have to find the time to write a judgment, because until they write a judgment, you can't go to the next stage of appeal, which is the High Court. So I'll give you an example of a case we argued, I think, in 2022. The decision came out in December 2023, and I've just had a letter from the Special Commissioner saying they will only give us the written grounds of judgment in December 2025, which means I probably can't have my appeal heard in the High Court until 2026, and then there'll be appeal to the Court of Appeal. So you imagine how long that process is.
Sorry, there's a common theme I'm picking up here, Dato'. Not enough resource allocation at the AG's office or the AG's chambers when it comes to international borders. There's not enough resources for Inland Revenue Board to look at the cases. There's not enough resources at the tribunals to hear those cases. There's not enough resources among the judges. It seems like there's not enough resources everywhere.
So this is what I mean about recourse. They've beefed up the enforcement arm of the Inland Revenue. Fine, all good, I accept that. You do need to raid some people. Some people will not pay tax if they don't have to, and you do need to go after these people. Some people, you know, will keep 3 sets of books, and the only way you can catch them is if you actually go to their office in a team of 20 or 30 people and look at those books. All well and good, I support going after these people. But often, these things are not properly done. So if you're going to beef up your enforcement arm, you must also beef up your recourse arm. You must beef up the number of people. You must expedite the speed with which the appeals or challenges are heard. You must put time limits for the courts to hear those appeals and dispose of the appeals. And to be fair, you must then give the courts the resources to hear those appeals and dispose of them in that time limit. Otherwise, it's basically a one-way street. I can raid you, I can demand the money up front, because that's our law. You pay first and argue later. And then the Ministry of Finance, which governs the allocation of resources to hear the appeals. This is not the judiciary. Special Commissioners of Income Tax is not a court under the control of the Chief Justice. It's not appointed by the Minister of Law. The number of judges in the Special Commissioners of Income Tax is appointed by the Minister of Finance, who is also our Prime Minister, and has been for years always and they don't appoint enough judges in the Special Commissioners of Income Tax. So you beef up enforcement, you slow down recourse. Is that fair? Is that fair? So, you know, and I remember us speaking to somebody very senior about this, and the answer that was given was, oh, well, your clients are very rich, they can do national service. That's not the answer.
No, that's not the answer.
If you want them to pay
economic
more tax,
standing of a client is not the precursor to having fair and justice.
And it may be that my clients are rich, but not every person who's unfair with tax assessments is rich. That's number one. But number two, if you want to raise more tax, do it properly according to the rule of law. Amend the law in Parliament. You know, there's a number of cases over the last few years that I've won in the courts, and Parliament has amended the law to get around it. Fine, that's the role of Parliament. That's how you do it. You don't do it by choking off the recourse mechanism that's given to taxpayers. There is one further recourse mechanism, which is you can bypass this whole special commissioner process by going direct to court for judicial review.
Oh. Okay.
You can, and the courts have said because Parliament has created a special mechanism for recourse, you should at first instance go there. Only in special cases will we hear you directly, and that's legally correct.
Yeah,
but you know, so in some cases they will give that mechanism, but by and large the courts say, look, Parliament has said you go to this mechanism, you deal with it. There is a special court of specialist judges to hear this. Go to them. That's the law.
Do you think that the situation is going to get more dire, or there are some hints of how this situation is going to be corrected?
No, it's not going to be corrected. Unfortunately, nobody is looking at it from the perspective of the taxpayers. Nobody is considering the macro position that taxpayers look at these things as one of the factors. It's not the only factor, but it's one of the factors they consider when they're investing in a country. If I invest in a country, I mean, let's take a step back. It is well known, the UN has written papers, the Nobel Prize last year was given to people who talked about why some countries are more successful economically than others. And one of the important factors is the security of your economic rights. Countries which have secure economic rights, secure recourse against governments that seek to confiscate their economic rights, have faster economic growth overall. How do countries seize your economic rights? An important factor is taxation. What is taxation? It is seizing a portion of your property. That's fine that you do this to finance things, that's all well and good, but you must have a proper recourse mechanism to challenge an unfair seizure. So if the government tries to acquire my land, I can go to the High Court, I can get a hearing quickly on that. If the government wants to seize my car, I can go to the High Court, I can get a hearing, or I can go to court. But if the government tries to take tax from me, seize my money from tax, I've got to wait 10, 15, 20 years to get my recourse. That cannot be right, and much needs to be done. But there isn't really a recognition of the need to beef up the recourse mechanisms for taxpayers. The courts, the government did a wonderful thing in the last 15 to 20 years by beefing up the courts. You know, in the 1990s, it could take you 15, 20 years to get a case heard through the courts. Tun Zaki came in as our Chief Justice, was it in 2008, 2009, and said, this is rubbish, a case should be disposed of within 9 months. If you're going to have proper access to justice, you must dispose of the case within 9 months. And to be fair to the Prime Ministers at that time and the Ministers of Finance, they allocated the resources to the courts so that cases could be disposed of. Okay, maybe not within 9 months now, maybe we're a little slow, but we're talking within a year and a half. You'll have your hearing, you have your decision. That's fair, and that's fast by international standards, very fast by international standards. We're amongst the fastest courts in the world in Malaysia. We're, you know, and each of the Chief Justices since then has pushed that.
You're speaking past tense right now. You're speaking past tense. It's like...
No, but the current Chief Justice also has done wonders. They've all, by digitalizing the courts, the current Chief Justice has also expedited these processes. We have one of the most digitalized court systems in the world. So when you had lockdown all over the world during COVID, all over the world, Hong Kong, whatever, their courts were shut down. Our courts were functioning because everything was online. The judges could work from home. The lawyers could work from home. And everything could be done online. That was fabulous, and that was the current Chief Justice, and I have no doubt that the next Chief Justice will also promote this. But when it comes to tax, which is not under the purview of the Chief Justice, but under the purview of the Minister of Finance, nothing has been done. The processes today in 2025 are as slow as they were when I started practice in 1985, or slower. In 40 years, we have done nothing to improve the delivery system of justice in the tax, in challenges to tax.
The Ministry of International Trade and Industry keeps on saying that we're getting this much billions coming in, approved FDIs. Clearly that is indicative that foreign investors are not shying away from our markets. Is that something of a counter argument to the assertions that you're making right now?
No, and it's not. That's a counter argument for specific sectors. These people are coming in because they're given specific incentives to come in. So that is industries that is being driven by MITI. But are we satisfied merely to have sort of a top-down economy where the Ministry of Finance says, I want $1 billion in investment in data centers, and so I'm going to give an incentive for that? Or do we want organic growth? Do we want people to come in, not because the ministry targets them and says, come in and I give you a special incentive, but people say the environment here is so good that I want to come into this country. I'm knocking on the doors, both foreign investors, but secondly, even Malaysian investors say, I'm going to stay in Malaysia because it's so good here. I don't have to go to Singapore, Vietnam, or wherever else. Everything works here like magic. And that's what we want. There is really no reason. I don't think that the failure of the delivery systems in respect of tax, challenges to tax, is an act of commission.
Yeah.
I think it's an act of omission. Nobody thinks about it, so nobody does anything about it. It's not that they've deliberately set out to stymie taxpayers. It's simply that they think, well, we passed this law. The law says you have this recourse, so it is done. I think, therefore it is, rather than I think, I have to act, and therefore it will be. So that's really where we are. Nobody's looking at this.
Final comments, Dato, in terms of where do you think the political will is going to come from? Do you think that we need a political champion out of this? Do you think that people need to, I mean, politicians are only as responsive or as sensitive as the populace is? Do you feel that there is a need for us to create awareness amongst the people so that the politician can react towards the needs and wants of the people? How do you think this is going to be resolved?
Well, this is always a big problem in every country. 90% of people in Malaysia don't pay tax. So they don't care about challenges to tax delivery systems. This is for the politicians to stop being politicians who respond merely to Trumpian politicians who respond merely to what people out there say, and move to the level of statesmen or stateswomen who think about what the country needs and put that in place. Stop being a Donald Trump, become a Lee Kuan Yew. Think about what is necessary. If you think about Singapore, they also had the same problems as us. In the 1990s, Singapore said, well, if we're going to progress and become a first world economy, we need to improve our justice system. We need to put grease in the wheels of the justice system. We need to allocate resources for all of these things. And they went right out and did it in every aspect of their justice system. In and of itself, that won't bring you foreign investment.
Yeah,
but it is one of the factors that improve. So really, if you have a Ministry of Finance, you have all the civil servants, thousands of them in the Ministry of Finance. Think about this. Think about the importance that if when you are plucking the goose's feathers, give him an avenue to hiss rather than run away because he just says this is not a country that is friendly. This is a country where the rule of law, right now we're in a situation where you could, with some stretching of the truth, say this is a country where the rule of law applies in everything except your right of recourse against tax assessments.
I would end there, actually. That would be one way to end an interview. That was Datuk Nitin Nadkarni, the consultant at Lee Hishammuddin Allen Gledhill. It's always a riveting conversation to be had. One thing that I will promise, if you would have me again, I would definitely have another conversation with you on many other topics as well.
I'd love to. I'm now a consultant. That means I have more time. I don't have to just spout at the kedai. I don't have to just spout at the kedai kopi mamak. In the kedai mamak, I can spout on camera instead.
Consultant is one way of saying semi-retired. That was Datuk Nitin. He is, of course, the consultant at at Lee Hishammuddin if you've missed any part of this interview, or if you want to learn more about some of the past interviews, just head on to AstroAwani.com and search for Datuk Nitin. Till then, thanks very much for watching. Catch you in the next one.
Thank you.
Thank you.
Okay.